Hello, and welcome back to the Global Students Introduction to the Law of the United States. I am Professor Pedro A. Malavet of the Levin College of Law, and today I will be speaking about constitutional implementation. Last time I spoke about the three governmental powers of the United States. Today I speak about how they exercise their authority and how they relate to each other. The implementation of the Constitution requires an understanding of the concept of separation of powers. As I discussed last time, the Constitution didn't pretend to answer all the questions about how the power of the government of the United States was to be exercised. In particular, how the powers of each branch of that government were supposed to relate to each other. So, political and legal conflicts were expected to arise, and in fact have arisen throughout our history, and they are often resolved politically through a compromise between the legislative branch and the executive branch. But sometimes the political branches of government are unable to resolve their disputes, so therefore judicial intervention will be required. Another subject that I must discuss today is the immoral institution of slavery, which is unfortunately a cancer that was left in our Constitution that could not be resolved by any political or judicial compromise. Separation of powers, as Professor Burnham has defined it, there are principles that are sure that none of the three branches of government, of the federal government, legislative, executive, or judicial, oversteps the bounds of its proper constitutional role, usurping the power of the other. This might seem a simple concept, but in operation it is not. In operation, what happens is that there are checks and balances. There's a sharing of institutional power among the three branches of our government. And the separate institutions must cooperate to some extent in exercising a great deal of the power of the national government. The two political branches, of course, and the judicial branch. And this is where balancing is required. To the extent that sharing of power is built into the Constitution, how that power is to be shared is balanced, again, through a combination of political process and sometimes judicial decision-making. The separation of powers of the United States government is fundamental to the constitutional structure. These three branches of government are separate, but they're equal under our Constitution. That's why they're specifically set out in the three first articles of the basic charter of the United States. The sharing of power was intentional. The founding fathers knew that it was important for the branches of government to work with each other in order to have a functioning national government. But they understood that checks and balances would be useful, indeed necessary, for the evolution of our national government, and also to make sure that no one branch of the government was too powerful. To put it in graphic terms, you have the legislative, executive, and judicial competence, legislative, executive, and judicial authority. There are certain areas where they don't have to share any power with any other branch of government. And then there are areas where the different branches must cooperate with just one other branch. And then there are areas where all of them have to cooperate. To give you a very simple example, the executive and the judicial branch cannot operate without money. The legislative branch has to give it to them. Another constitutional provision that is fundamental to the functioning of the United States is the Supremacy Clause. The Supremacy Clause provides that the Constitution of the United States and the laws that are passed under it are the so-called supreme law of the land, meaning that in the hierarchy of laws, the Constitution the federal laws and treaties that are entered into under the Constitution are supreme and displace any incompatible state law or any incompatible regulatory act. This is the primary source of federal judicial power. This is what gives our Supreme Court and the federal courts more generally the power to enforce the Constitution even on the several states. The concept of judicial review is today fundamental to the way the Supreme Court of the United States functions. But in the early days of the Republic, it wasn't entirely clear that it existed. Of course, ours is a common law tradition. A common law tradition does implicate courts that issue judicial opinions that are generally binding. But does that rise to a constitutional level of authority? Well, Chief Justice John Marshall so ruled in one of the most important decisions ever issued by the United States Supreme Court, Marbury versus Madison. And you see here a picture of the Chief Justice and the actual order that was issued in the Marbury case, as they are kept by the United States National Archives. Marbury. In 1803, the Supreme Court of the United States rules that it is emphatically the duty and province of the Judicial Department to say what the law is. Those words are extremely significant. The duty of the Judicial Department to say what the law is. Judicial review, that the courts have authority to interpret and to apply the Constitution of the United States. Justice Marshall understood that judicial review was necessary, and he found it in the Constitution itself. The Supremacy Clause that I talked to you about provides that the laws have to be followed by all. Well, in a common law tradition country like ours, it is the courts that enforce and interpret the laws. Article 3 expressly says that the judicial power of the United States is vested in the federal courts, and therefore it is the traditional role of the courts, the one that guarantees to them the authority to issue case law and to resolve legal disputes, that is enshrined in Article 3. And lastly, constitutional hierarchy. The Constitution requires that any law passed within the United States be subordinate to it. The Constitution is our fundamental charter. It is the single most important law in the United States and has been so for well over 200 years. And sadly, I must finish this section of our series by discussing slavery, the immoral institution of slavery. Unfortunately, slavery was constitutional. Not only that, the Constitution enshrined slavery as an institution that could not be invalidated by the United States Congress. But interestingly, they chose not to use the word slave in the Constitution. But it was very clear, and it was so resolved by the Constitutional Convention, that slavery could not be abolished. In addition to that, slaves, chattel property, human beings that were chattel property, would be counted towards the congressional representation of their owners. The Constitution has 3 articles that are expressly designated to protect the institution of slavery. Article 1, Section 2, Clause 3 states that a person bound to service, slaves, were to contribute 3/5 to the congressional representation of their masters. Article 1, Section 9, Clause 1 limits the congressional power to restrict the slave trade. That is the provision that prevents the Congress from abolishing slavery. Article 4, Section 2, Clause 3, a person held to service must be returned to their master when they're able to escape them. So the runaway slave cannot be free. So to conclude, our Constitution, after setting up the basic branches of the government, moved forward, primarily thanks to the concept of separation of powers and checks and balances, and when political disputes could not be resolved, thanks to the concept of judicial review, to the power of the courts. And this worked generally quite well. But unfortunately, the Constitution left an unresolvable issue in it, and that was slavery. This was a problem that could only be resolved by a bloody civil war, and we will discuss that in our next session.